Washington. Anyone know where Soap Lake is? Yeah, okay, good. Dan Hayes was from Spokane, Washington. They could have practiced anywhere they wanted to in the country, but decided they wanted to be here in Spokane and raise families. Even when they split off from their prior law firm and to start Lee and Hayes out of their basements 23 odd years ago, and Microsoft wanted them to move over to Redmond, they said, no, we're going to be in Spokane. This is where we want to set down roots and everything. So that's very much ingrained in kind of the culture of our firm. You can see some of the recognitions we've gotten, including we were ranked for 4 years in a row as the #1 law firm in the United States for overall patent quality, and that's International Asset Management Magazine out of the UK. So again, this is kind of our reach in Spokane, but have offices in Seattle, Portland Metro, it's really in Vancouver, Austin, Texas since 2008, Atlanta, Georgia, have a small office, some people outside of DC and the Reston, Virginia area, and then a couple of people up in Rochester, New York, with clients kind of essentially worldwide. About when I started at the firm 9 years ago, we were going through this big kind of rethinking how we're going to diversify. We were too dependent on a few large clients. One of the things that we did to diversify was start a corporate group, and that was kind of when I started. We also have litigation and that kind of stuff as well now, but that was about the time when we decided, look, we can do a 180 and say, hey, let's move into an office with an actual reception area, and people, hey, Spokane, we're here. We want to do work with Spokane companies and that kind of stuff. So that's always been kind of my focus, is kind of more the regional clients. I do some occasional work for some of our larger clients, but mostly Seattle, Portland, and a lot of Spokane stuff. I am the so there's the next one. So I am the chair of our corporate and IP transactions group. My focus, the focus of my practice is corporate and securities focused around startups, intellectual property, mostly around transactions and what we call the soft IP, and I'll talk about that, mostly trademarks and that kind of stuff. And then also kind of business transactions around anything my clients want to or need to do. So act as outside general counsel to innovative technology companies mostly, okay? All right, so today we're going to talk about intellectual property. Okay, and whenever any startup comes to me and says, look, I want to start a firm, or I want to start a company, what do? I always start with intellectual property first. We always talk IP first. And there's a couple of reasons for that, but the main reason is, for most companies, if you don't have something to protect, then you don't really have a business, right? If you don't have something that you can latch on, identify as being yours, then you can't answer that question of what is my sustainable advantage, right? You might have a great idea, but it's just a flash in the pan, right? If there's no barriers to entry and competitors, the bigger guy can just come and take over the market and copy what you're doing. All right, so intellectual property is the solution that I start with, at least, for anyone asking, what am I going to do to start a business? How can I make this a sustainable business? What are the barriers to entry I can put up so that I have a competitive advantage? Okay, so we talk about IP first. So why is IP important? Number one goal of today's talk is just to convince everyone in here that intellectual property is important and should be something that is on everyone's radar. Even if you just have an idea and haven't launched anything yet, or if you've been going for several years and have never thought of IP or whatever, you need to be convinced that IP is important. So that's goal number one. And here we go. Okay, July 29, 2016. Does anyone know what happened on that date? That was super important. Okay, not really super important to everyone, but we're going to come back to this. I'll tell you why it was important. We're going to talk about a couple of macro events first. So the first one is, we're in a global innovation society, right? Economy. Everyone knows that. That's not news. What was Friedman's book, The World is Flat, right? That came out a long time ago. You can innovate anywhere in the world and come up with something that people will buy or pay you for because of the internet, mostly, right? So the world is flat. We're in a global innovation economy. Everyone understands that innovation is key. It's a buzzword that everyone talks about. Here's a great quote that we like to kind of reiterate from time to time. Innovation is at the core of what we do at Xerox. This is by the CEO of Xerox, by the way. I think most chief executives would say that, and if you don't, you shouldn't be a CEO. Okay, we're talking about Xerox. They've been around for a long time, right? And they do copiers. That doesn't sound that fun. But what she's saying is to survive, even they need to be innovative. And that is the key of today's economy. Okay, so everyone can kind of buy into that, I assume. But the point that I'm going to try to convince you about is that innovation alone is not enough. Right? If you come up with an idea and you don't protect it, if you come up with some innovative technology and you don't protect it, your idea is their idea. Okay? Someone's going to steal it and do it better than you or take over the market because they have deeper pockets. So the key is protection. Innovation plus protection equals prosperity. Okay. So one of the many amazing things about the United States of America, our country, is that we are one of the only countries in the world, if not the only country in the world, that has intellectual property laws based in our Constitution. Okay? It was, promotion of the useful arts and art, creative art, useful and creative arts. Okay? So the Constitution was enacted and ratified. It had the concept of intellectual property, specifically patents and copyrights, in the Constitution. Took a couple of years for Congress to finally enact the first Patent Act, but they did it in 1790. Does anyone have an idea or a guess of how long it took to issue 1 million patents? Okay, we started in 1790. How long do you think it took to get to 1 million? 200 years, Chris? That's pretty good. It's pretty close. Guesses? 121 years. Okay, 1911. This is kind of a cool chart too, because you can see the millionth patent was a vehicle tire. That makes sense in 1911. Innovation around, around cars and that kind of stuff. Okay, that all makes a lot of sense. But 121 years. Okay. So then what happened? Next million. A lot less. 2 million. 3 million. 4 million. Now see what happens here. Okay. So you can go million, 2 million, 3 million, 4 million, 1935, 1961, about 30, 25, 30 years. Again, into the 70s. Makes sense in the 70s. They're doing stuff around, around petroleum and gas products, petroleum products in the 70s. 1991, and then let's see what happens here. All of a sudden, 8 years, from 91 to 1999. Well, what happened in the 90s? Software became patentable, early 90s. It's about the same time that Lee and Hayes started, 1992, so that makes sense. So 8 years, 7 million, 7 years, 5 years, to get the 8 millionth patent in 2011. And then, of course, it was only 3.5 years to get from 8 million to 9 million in 2015. That was about April of 2015. Guess what threshold we just passed a couple weeks ago in June? The 10 millionth patent was issued in less than 3.5 years. So it's going even faster now. Isn't this amazing? It's remarkable. So yeah, we had the basis of protecting useful inventions from all the way back in 1790. But now, people are getting it. Why is that? Why is that? Because there's so many different ways now that people are utilizing technology, right? I mean, how many patents are just around this thing? How many? This spawned a whole industry of technology and patents, right? And litigation, sure. Okay, and we believe that it's no coincidence that along the same lines is you can watch the acceleration of innovation and protection of innovation, the global per capita income is skyrocketed, okay? Our life has become better because of this stuff, okay? All right, so innovation is key. Protected innovation is super key. Macro event number 2, the market has woken up. The market now rewards protected innovation. Okay, formally protecting ideas increases the value of your company. All right, both with investors and potential acquirers. Okay, here's an example. Back in 1975, we had about 80-85% of the value of the S&P 500, the top 500 stocks in the United States, was tangible assets, okay? We had about 20%-ish, 15-20% that was intangible assets. And most of that was what accountants like to call goodwill, right? When you're valuing a company as an accountant, maybe you're doing the books for an acquisition or whatever, there's usually some delta between what you can attribute to the tangible stuff and what someone's actually willing to pay. Accountants usually say, well, that's the goodwill, all right? Goodwill's wrapped around your brand and your trademark, so okay, great, that's an intangible asset. Here's an example of kind of the top 5, biggest, biggest companies in that times, yeah. And then all of a sudden, now, we've had a complete rotation. Over 85% of the value of today's S&P 500 is in intangible assets. Intangible assets. And look at these companies down here. Apple, Microsoft, well, Exxon, Johnson & Johnson, Amazon, Facebook. What the heck is Amazon? What is Apple? Where does Apple get all that value to be, the largest or one of the largest companies in the world? It's not because they have a stockpile of these things sitting around and they have inventory. It's because they own IP that is super valuable. It's all about IP. So these are now the S&P 500. The point is now the S&P 500 is dominated by IP centric companies. All right. And here's kind of a chart that shows that 2015 was the last one I have on the chart there. 84% of the value of the S&P 500 was in intangibles. There's that date again. July 29, 2016. What happened? Well, this is the recap. We know macro event number 1. We're in an innovation society. The market has woken up. That's macro event 2. Still is the basis of what's Microsoft? Has anyone been to the Microsoft campus in Redmond? It's pretty cool, right? They have cool buildings. They have great stuff there, good people. That's not the value of Microsoft. It's in the 60,000 plus assets, patent assets that they have these days, okay? The result of all of it is intellectual property is the single most valuable asset class of today's economy, okay? It's hard to dispute it at this point, all right? So, as startups, what does that mean? What does that mean? It means you should at least appreciate intellectual property and how it applies to you and what you're doing, right? You have to at least understand it and be aware of it and say, wait, I need to go talk to someone because I think I have something here, right? And maybe spend some money on it. Because spending money on intellectual property is acquiring what could be the most valuable assets of your company. This is kind of a cool part of being a part-time intellectual property attorney. I look at clients in the eye and I say, I'm different than going to other attorneys. Because usually, people think about, well, I want to avoid an attorney at all costs, right? Because they're expensive, and it's normally when I have a problem, right? And I'm between a rock and a hard place. I have to go to an attorney. But with intellectual property, you get to go to an attorney, right? because I get to go there to build what could be the most valuable assets of my company. All right? So you have to kind of do a paradigm shift there and think about it in the context of, if I'm a server operation, or I require a big server farm for my company, buying a new server is an investment in my company, right? So I can grow. Same thing with intellectual property. Okay, so in order to utilize IP as a startup, we got to understand IP. So everyone understands, first of all, when I say IP, we're not talking about internet protocol, we're talking about intellectual property. Okay, so what is IP? IP in general, when we talk about intellectual property, it's the four main buckets, okay? 4 buckets: patents, trademarks, copyright, and trade secret, okay? If you think you have something that's protectable, and you want to explore kind of IP protections for your company, you go through the process of examining each of the 4 buckets and determining whether or not it's applicable to your situation, okay? That's kind of the process we go through. I see a ton of startups that come to me and say, I think I have something here. This is the best thing since sliced bread. How do I protect it? And the process we go through is an analysis through the 4 buckets, okay? There's also this other thing we call know-how. It's kind of the primordial ooze of intellectual property. Everything's know-how, right? If you start a business today, okay, well, say you started a business a year ago, and you're at the 1-year mark of your business right now, and you look back at the last year, you say, boy, things are running a lot smoother now than they were a year ago. Why is that? Well, I've learned a bunch, right? I've learned a bunch. Who to work with, which vendors to work with, how like what the timing, lag time for ordering certain supplies, all that stuff is know-how. If you were to sell your company, those people, to be successful, you might have to teach them, right? So there's something there. But as know-how starts to kind of develop, then know-how can be distilled into maybe one of these 4 buckets. So everything starts as know-how, and then we go kind of forward from there. Any questions so far? Okay. So when I talk to any startup about IP, again, I say that someone comes to me as a startup entrepreneur, I want to talk about any of the legal issues that I need to deal with or have on my radar. We talk about IP first, and within that, the thing that we always talk about first is patents, okay? Why do we talk about patents first? Because patents are king. It kind of pains me to say that. 2/3 of our attorneys at Lean Hayes are patent attorneys still. And so, they're like, patents are king, yeah. And they say, well, Dan does soft IP. And I say, well, yeah, okay, patents are king, but we'll talk about trademarks in a second. I'll tell you what's cool about trademarks. But okay, patents are king. Why are patents king? Because if you get a patent around your technology, you literally carve out some space that is just yours. Okay? Talk about a great barrier to entry. It's the supreme type of intellectual property. All right? Has anyone read a patent before, or patent application? Any inventors or named inventors? No? Oh yeah, okay. It's got to be way more than 3. All right, so patents. This first picture here is the front page of a patent. Patent attorneys spend maybe 30 seconds on that first page if they want to know about that patent. Okay? They look at the dates, they look at the numbers, they maybe read this abstract, which is a 1-paragraph kind of summary of what the patent is. But then a patent attorney, or anyone that lives in the IP space and knows how patents work, if they want to know about that patent, they turn to the back of the patent. Okay? They go to the claims. All right? The claims are the metes and bounds of the property right. Okay? So everyone understands metes and bounds. Like if you're surveying a piece of real estate, the surveyor, puts stakes in the ground, and then they describe this weird, description of what the property is. It's, from the northwest corner to the southeast or whatever it is. And those are the metes and bounds. That is that describes what it is you own. You own everything within that description. These are the metes and bounds of your property right, of your patent property right, okay, of what you own. All right? The claims are the most important. You might see stuff in here that freaks you out, or maybe you know, the first thing that we tell people to do, okay, if they think they have something that's patentable, we say, go do your own searching first, okay? Go do Google Patents. They have a pretty good user interface. You just do keyword searching, and hopefully something valuable will come up, all right? Something that's informative, at least. You might get freaked out by what you see. You might say, well, crap, someone's already done what I'm going to do. I'm out of luck. Turn to the claims and see what's in the claims. Some claims are narrowed so much that you can design around it pretty easily and not infringe that patent, okay? Maybe there are actual dimensions of certain features of the widget that is described or protected by the patent. And if you go around those dimensions, then you're not infringing, okay? The claims are the key part. So claims are kind of funny. My patent attorney colleagues say that you know, college and law school teaches you how to be a good writer, and then you get into the real world being trained as being a patent attorney, and they teach you how to be a very bad writer, because this is all one sentence, okay? Run-on sentences are the thing in the patent world. You have to use them, okay? Okay, so just a little high level about patents really quick, and then I'm going to dive into a couple misconceptions. So when we talk about patents, we're usually talking about utility patents, okay? Patents that protect useful inventions, all right? There's also design patents, and people should not just forget about design patents because sometimes they're super important and valuable protections that you can get for what it is you're doing. Maybe it's a graphical user interface, or just the look, the ornamental look of something that you came up with that you designed. Okay, that's design patents. But usually when we're talking about patents, we're talking about utility patents. Utility patents protect the functional aspects of virtually anything, and the requirements for protection is it has to be useful, which is the easy one. If you came up with it, it's probably useful, right? Novel means new. No one's ever done it before. And it has to be non-obvious. Non-obvious is the one that, that's why the patent attorneys make the big bucks, okay? This obvious thing is kind of a tough one to overcome sometimes. What is obviousness in the context of patents? Obviousness is if you came up with something and it applies to this industry, or you're solving this problem within your market, your industry, but it just so happens that over here in this other market, they're doing something really similar, using kind of similar techniques to solve a different problem in that market. What the patent examiner asks is, if someone that of ordinary skill in the art in that technology space knew about this over here, would it be obvious? Would your invention be obvious? Okay? So you can imagine there's a lot of rejections like that, and that's the process for filing for a patent is a long one, okay? You first of all, it costs a lot of money. You know, we quote people $8,000 to $12,000 just for a patent application, okay? And then you get it into the hands of the USPTO after working with your patent attorney for a long time, and you get into the hands of the USPTO, and about 1 to 3 years after that, they pick it up and reject it, okay? Awesome, right? I just spent a ton of money to go get something rejected. Actually, no, that's a good thing, right? If your patent doesn't get rejected, that might actually mean that your patent attorney didn't draft the claims broad enough. Because the patent attorney's job is to get as broad a claims as possible for what it is you're inventing, or you have invented, okay? On the other hand, the USPTO patent examiner, their job is to narrow your claims, essentially. They do a search of all the prior art, anything that was out there before your invention, before your filing date, okay? And based on that prior art, they'll pick apart your claims and say, that's obvious, that's not novel, that's not patentable subject matter, whatever it might be, okay? And then that's kind of, so 1 to 3 years, they'll reject it. They issue what's called an office action. Your patent attorney will then have a back and forth with the patent examiner in what's called the prosecution stage, okay? And eventually, the two will hopefully land on some middle ground that they agree is allowable, okay? And then it'll be allowed and then can finally issue to a patent, okay? It's not cheap, but the point is, and what we try to do for our clients is, you know, for every dollar that you spend, we want it to be an important business asset. So there's a purpose, a business purpose for acquiring this asset, and we want it to be worth at least 10 times as much, if not more, okay, for your business. Foreign filing, we won't really get into. The point is, on this presentation today, this is super high-level stuff. We can spend an entire law school semester just on patents, just on trademarks, et cetera, et cetera. But if anyone in the room here has questions, feel free, okay? So, how do patents work? My friend Chris here. No, I'm going to use you next. So I come up with a new invention. We're just going to pretend, okay, for sake of argument, that no one has ever seen anything you can sit on, right? We all just stood or sat on the ground or squatted or whatever, okay? And so I came up with this brilliant new thing that I call a stool. And so I bring it to my patent attorney, and this is what my patent attorney writes as a claim. They say, a device comprising a platform and at least one leg supporting the platform above the ground. Okay, that's a stool. At least one leg supporting a platform, great. I can sit down on it. I get a patent issued, okay? That's kind of the scope of my stool patent. And I go out and I start selling stools. They're selling like hotcakes. No one's ever sat before. It's a brilliant thing. Okay. But then my smarter friend over here, Chris says, Dan, well, he doesn't talk to me. He just thinks. He sat on one of my stools. Maybe he paid for one of my overpriced stools. And he said, this is great, but my back hurts. I want to lean back. What if I just put like a back support on this? So he invents something new. It's an improvement on my stool. And he goes to a patent attorney, and his patent attorney says, okay, well, your thing that you're calling a chair, I'm going to describe it this way. A device comprising a platform, at least one leg supporting the platform above the ground. Okay, so far identical to mine. But also a back support attached to the platform extending in the opposite, from the platform in a direction opposite of at least one leg. Okay, that is a stool or a chair. Chris can get a patent on that. That's called an improvement. So he gets an improvement patent. Question, can Chris make and sell his chairs? He got a patent on it, right? I mean, people say, most people think if you get a patent, that means I can go sell what it is, make, sell, use what it is that I got a patent on, right? Wrong. That's actually wrong. The single biggest misconception about patents. Single biggest misconception about patents. A patent does not give you an affirmative right. It gives you a negative right. And I'll get to that in just a second. So he gets a patent issued. That's great. It's a valid issued patent. But he cannot do anything with his chairs. He can't make, sell, have them made by someone else, or import them into the United States because it would infringe my patent. See how his chair patent, the scope of his chair patent is completely within the scope of my stool patent. In order for him to make a chair, it necessarily has these two elements, and that's all I have in my patent is these two elements. If he has those two elements, he's an infringer. So what do we do? Because all of a sudden, the market agrees with Chris. The market doesn't want my stools. They want to be able to lean back. So what do? Cross-license. We talked to Chris comes to me and says, Dan, you're missing out on this because I can't make chairs. Okay? He has the patent for chairs. I can't do this part, this last bullet point. I cannot put backs on my stools or else I'm infringing his patent. Okay? So we get together and we say, the market wants chairs. Let's cross-license. I'll give you a license to my stool patent, and you can make your chairs. You give me a license to your chair patent, and I can make chairs too. Okay? So patents give you a negative right, a right to exclude others from having someone else make it, importing your invention, what it is that's described in your claims. Okay? Questions about that? That's the first mind-blowing thing. And don't feel bad. Everyone, not everyone, a lot of people get that wrong. If you don't live in kind of this space and understand this, a lot of people have that. That's the single largest misconception. Okay, questions? Yeah.
Big chair company beats up the stool company in court.
Yeah, so if Chris said, I don't care if I'm infringing, I'm going to go sell because I have deeper pockets than you, and I say, well, great, I'm going to go sue you, Chris, because you are infringing. Look, if Chris has a bunch of deeper pockets, much deeper pockets than me, then he could make my life pretty terrible because he would throw my patent into re-examination and try to invalidate my patent and do all those things. And so, yes, unfortunately, that's kind of the world that we live in, that money plays a big part in kind of the enforcement and defense piece of this stuff. Okay, but the good part, okay, the good thing is that most companies will not intentionally infringe someone else's IP. Okay, most companies will not do that because they're IP holders themselves, and they understand what it'd be like. So yeah, there are examples of the big guy pushing the little guy around. There's also examples of the little guy winning, and winning big, right? RIM versus NTP. The BlackBerry, there's big BlackBerry litigation. That's when the market really woke up to IP. Our firm was hired by Goldman Sachs to track that case and predict what was going to happen with RIM's stock price, and it was amazing. Because they woke up and they traded based on the information, and sure enough, it was a very good thing to get that litigation behind RIM, even though they paid. The initial offer was something like $10 million by the plaintiff, and they ended up selling for like $600 million. So okay. When to use an attorney? You want to use an attorney for patents, okay? No question. Go early too, because now we're in a first-to-file system in the United States, which is in line with most of the rest of the world. If you invent it at the same time as someone else, or around the same time, but they get to the patent office first, guess what? You're out of luck. They beat you to the patent office, and you can't get protection. They get protection on the invention, even though you invented it too. Okay, so you want to get stuff on file early, often. You want to have non-disclosure agreements, which we'll get to a little bit later. You want to treat your invention and what you're going to disclose in the patent application as a trade secret. Okay, and don't disclose to anyone unless you have a signed NDA, because if you do a public disclosure or you sell your widget that you came up with that incorporates your technology, your patentable technology, then you have only 1 year to then file a patent application in the United States, or else it's out the window. It's in the public domain. Okay, you don't have any rights. So that's a key point for startups, because everyone's like, well, Dan, I don't have the money to spend, to do a full-fledged patent application. Well, what do you do instead? First of all, investors, for instance, are not going to sign NDAs, but the key is you should and can and absolutely recommended that you figure out how to convey the message of what it is that you're doing without disclosing the how, okay? Because it's the how that's going to be protected in the patent. Okay, it's the specifics of how you solve that problem. So to investors, you say, I solved this problem, and just vaguely speaking, we took these angles. I'm not going to give you the specifics. If you want to know the specifics, you have to sign an NDA. Okay? Yeah. Yeah, it does actually. So, yeah, so you have that kind of safe harbor there. But we tell our clients, so the law is in somewhat flux around kind of the 1-year safe harbor because of the AIA that was enacted 5-6 years ago now. There hasn't been a lot of case law interpreting kind of the new language there. So our best practice recommendation to our clients is file before any disclosure or any sale, okay? And that certainly could maintain other foreign country rights as well, because as soon as you start selling stuff in foreign, then your rights in foreign countries could go out. They don't have the 1-year safe harbor, okay? So, so you want to do this early, and you want to have a strategy early, and it is possible to have a lean startup mentality strategy that still does what you need it to do and ultimately get some protection, okay? For me, the early pre-seed, kind of funding stage for people, there's no better use of your money that you might get from, friends and family or a pre-seed fund or whatever it might be than to file a legitimate patent application, okay? Even in some cases before other legal work, potentially, okay? So, so yeah, any questions about that? That was a good question. Okay, we're going to move on from patents, but patents are king. If you think you have something that's patentable, move early, talk to someone early, and go through the process of determining, is this a good use of my early stage funds? Because in some cases, the answer is absolutely yes. Questions? Okay, next. It's never too late. This is great. Okay. The other thing, one last thing on patents, just like the chair stool example, it's never too late. You can come up with something, and then once you look on Google Patents or whatever, you're like, oh wow, well GE and all these other big companies are already has all this protection in that space. I can't go up against those big guys and think I can compete. No, that's absolutely not true. If you come up with something that they haven't come up with and you file first, you're in the game. You're in the game. If it's a feature that the market wants, then you're in the game. All right? You've created something that's valuable. If you protect it, then all of a sudden, maybe you're on the radar of the big guys, and hopefully you are, because you're doing something that the market wants that they can't do. Okay? It's never too late. Okay, that was patents. Patents are king, but trademarks are awesome. Trademarks are awesome. Why are trademarks so awesome? Trademarks are awesome because we get them, right? It's easy to kind of understand. Everyone kind of understands trademarks because they're all over the place, right? They're everywhere. I can point to several trademarks right here, just standing from here. And we're inundated by trademarks at a really early age, all right? I have an example, my now 6-year-old, when he wasn't even 2 yet, he was 1.5, just kind of starting to talk and kind of figure things out. Driving up the street, he points out the window and says, Jimmy John's! Jimmy John's! What? Jimmy John? He can't read. He's not even 2. He can barely talk. How is he saying Jimmy John's? It's because he understands that logo means those scrumptious sandwiches that his mom buys him every once in a while. Right? Amazing. Amazing. So we all get that. I mean, we understand. Just do it. Nike. We understand all these different things. Trademarks are awesome. The other reason trademarks are awesome is my rebuttal to all of my patent attorney colleagues that say, well, Dan does soft IP. He's not a patent attorney. What's the single most valuable piece of intellectual property in the world? A trademark. It's particularly the Apple brand now. Used to be for years and years and years the Coca-Cola mark. So I say, what's the single most valuable thing? It's the trademark. Patents, by the way, I didn't mention it was on the slide, but patents only last for 20 years. That's the grand trade-off. The government gives you exclusive rights for only a certain amount of time in exchange for teaching everyone how to do your invention so that society as a whole is benefited. Okay, after your exclusive rights expire, then everyone can do it and we're all better off for it. That's the whole patent trade-off. Trademarks, on the other hand, are potentially perpetual in duration as long as you keep using them. As long as you keep using them. So you can think of all these trademarks that have been around for a really long time. Coca-Cola is a great example. I mean, long, long time. Generations. So what is a trademark? Trademarks are, at their basic level, a source identifier. Okay? That's all they are. So source identifiers can be a lot of different things. Most commonly, we think of trademarks as just words, right? Like Nike, or the words Coca-Cola, or whatever it is, Google, Exxon. But also slogans, right? We know about slogans, just do it, whatever it is. Logos, just symbols. The swoosh symbol alone, we know that's Nike, right? Logos alone can be source identifiers, obviously. Symbols, though, also. Colors, sounds, scents, and even designs, packaging designs, and that kind of thing. What? Colors alone? Think about, again, cell phone carriers, plant carriers, okay? Which one do you think of when I say pink? T-Mobile. Which one do you think of when I say blue? AT&T. Red. Yellow. Wow, they did a really good job, didn't they? All of those answers just prove the point. And the point is that colors in and of themselves can be trademarks because they're source identifiers. If I am walking into a cell phone store and it's pink, I know it's a T-Mobile store, okay? And it's enforceable. They've enforced it against each other occasionally. There was a AT&T subsidiary down in Texas at one point. They had a bunch of pink stuff up, and T-Mobile successfully got them to remove the pink stuff, okay? Protectable trademarks. You can even get registrations on those things. Colors, sounds even, okay? So the NBC ding, 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 right? That's a trademark, registered trademark of NBC. No one else can do that in kind of that space. So it's one of those things, a source identifier used in commerce in association with the sale of goods or services. And it has to be distinctive and can't be confusingly similar to another mark that's already pre-existing, okay? So used in commerce, that means that as soon as I start using it, I might have some rights, even without a registration. Patents, you have no rights until the government says you have a right, okay? Trademarks are not that way. Distinctive, we talk about the spectrum of distinctiveness. If you're a startup thinking about choosing a new name for your company, what are you going to do? Well, I'm going to come up with something catchy that makes people think of what I do, right? I mean, that's usually what people think. You should also think about this spectrum of distinctiveness. Generic marks are never protectable. If I was opening a brewery and wanted to name it beer, I can't do that because I can't keep others from using the word beer in their marketing, right? So generic marks are never protectable. On the other hand, the best, most highly protectable marks are arbitrary or fanciful or coined marks, right? So Apple for computers and for phones, everyone knows what Apple is. They didn't ever associate it with phones or computers until that company established that, okay? Exxon is a made-up name. Those are super protectable. In the middle is the sweet spot for small businesses and startups. Descriptive marks and suggestive marks. Suggestive marks require some leap of imagination, like Microsoft, software for microcomputers. Oh, I get it, right? Aha. Okay, that makes sense. That's a suggested mark. Descriptive marks are protectable if you acquire distinctiveness throughout the process of consumer identification, okay? So, yeah.
How does Walmart get
Always?
You can't use always.
They did what, they established they said, we're claiming rights in this through our marketing campaign, and they stuck to it. They spent a bunch of money, and you know, that is actually an arbitrary mark for what it is they do. people wouldn't automatically think of the word always as being a retail store or a giant retail store like Walmart or anything. And so they'd chosen a word and they built up rights. I'm sure they have plenty of registrations around that. And there you go. Totally legitimate. Totally legit. That's an arbitrary word. It's a strong mark. Now, you could say, well, does this mean they have a trademark registration for the word always? Walmart does. Does this mean I can't use the word always in any of my marketing? No, that's not what that means. You just can't use it as a trademark. Okay, so you can use it in a descriptive sense or in a useful sense. You're using the word always. You just can't have it up front and center in a different font, trying to be a source identifier of what it is you're selling. Okay, does that make sense? Okay, yeah. Sure. Well, you could do that potentially. Okay, but so if, for instance, you were a e-commerce or a brick and mortar retail store, and you said ours is always affordable or always quality or whatever it is, that wouldn't fly. Okay, because that's too close. We're going to talk about the likelihood of confusion, but that goes down to this mark here. It must not be the same or confusingly similar to another mark used on the same or similar goods or services. So that's whenever anyone, any startup or entrepreneur wants to adopt a new mark, I say, stop. Don't even talk to me until you do your own searching first, online, okay, just a Google search, and at uspto.gov. There's a pretty good user interface for their trademark search database. Just check it out. See what's out there. Well, okay, say I'm going to start a software company. I'm going to call it Zebra Software. Zebra is arbitrary for software. I'm going to add the word software so that people know what I do. Okay, that's a pretty cool mark, I guess. That's pretty good. I go and search for Zebra for names of businesses, and I come up with Ethan's babysitting service named Zebra Babysitting. Ah, crap. Ethan's already using it as a trademark. I can't do it. No, that's not true. That's not true. Because consumers would never be confused between a software company and a babysitting service. Okay? So that's why there's deltas. There's multiple deltas. Delta Airlines, Delta Faucets, Delta Tools, Delta Dental Insurance. They can all coexist harmoniously using the exact same main word as their main mark, because consumers would never believe that the airline was making your tools or the faucet company was flying your planes. Okay? So that's kind of, you're not searching in a vacuum, you're searching in the context of what it is. Are consumers going to think that I'm related to them somehow or something like that, okay? And so because of that, if you think of a bullseye target, the trademark rights are not just the bullseye themselves, what you describe in your trademark application or what it is you're actually selling right now. It's more of the entire target. So if you're looking at, well, someone's using my name, are they on the target at all? Then that's close enough, maybe. Okay? If they're not close enough and no one would ever come to them thinking they're me or vice versa, then maybe there's no problem. Yeah. Let me tell you another story. They'll answer the question. Mattoon, Illinois, Burger King, a mom and pop burger joint named Burger King. Okay, the big Burger King comes up, starts growing, gets trademark registrations in the United States, and decides they want to move into the county, around where Mattoon, Illinois is. And they say, hey, we have a federal registration. You don't. You just have this mom and pop shop, you're calling it Burger King, you need to change your name. The mom and pop shop fought them, okay? The mom and pop shop won against the big Burger King because they were established and well known as Burger King in that geographic area before the big Burger King got their federal trademark registration. Okay? So they could win. Next, flip side of the coin, Sonic Burrito. Anyone remember Sonic Burrito on Hamilton? Oh man, when I went to Gonzaga, that was Sonic. When I heard Sonic, we were going to the burrito place, right? Well, the Sonic drive-thru decided they wanted to come into town, into Spokane, and guess what happened? Sonic Burrito had to change their name. They changed it to Ionic Burrito, and now they went down and it's a Thai place, okay? What happened? How is that different than Mattoon, Illinois? In Spokane, when I heard Sonic, I thought of the burrito guy, not them. So it's the same as Mattoon, Illinois, right? No. The problem is the Sonic drive-thru had their U.S. federal trademark registration before the burrito place opened their doors. Okay? So you can establish common law rights in a trademark without a registration. Okay? But they are geographically limited to the extent of your notoriety of your brand. Okay? Does that make sense? So I would imagine that either Walmart said, fine, you have your little geographic area or whatever, or they said, we actually had a registration on it way before you even started. It was probably one of those things. And the little guy probably didn't have a federal registration, which could effectively stop Walmart from using it anywhere in the country potentially. Okay? Does that make sense?
Sonic did give audience.
Did they? Are you sure?
Sonic was my neighbor.
Oh, okay. Oh, okay. That's great. That's great.
So they didn't just totally squish it.
That's good. Well, that makes me feel better. See, I have a guy that happens to be in the office next to me here in Spokane that represented the bad guy there. And so I bring it up from time to time and tell him he squashed my burrito joint, dang it. Okay, what's the difference between the two pictures up here? And no wisecracks about basketball teams, right? I love that. We can say, well, WSU is not so good, right? We don't, well, that's a woman's sweater. Okay, yeah. What about, if you look closer here. So we have the marks, Gonzaga, Zags, the Bulldog, head. There's little things next to it there. Over here, there's a little thing next to it over here. These, the Gonzaga sweatshirt, those are TM. They say TM. The WSU sweater is the encircled R. What does that mean? You can use the TM symbol to say you're claiming common law trademark rights right away. Okay? Everyone should do that. Go put a little TM next to your trademark, your main brand. Go for it. Okay? All that says is you're claiming common law rights in the mark. You cannot, however, use the encircled R unless you have a federal trademark registration. Okay? And by the way, that law is pretty similar in foreign countries too. There's even like penalties, like in Mexico, if you use encircled R without a registration, that could be bad, theoretically. They don't really enforce it, but it could be bad. What does that mean? Gonzaga doesn't have registrations? What? No, they do. They have registrations, but for promotion of sporting events and educational services, they don't necessarily have it for sweatshirts. Why is that? Well, Gonzaga is actually the name of a saint, right? So there's a lot of other Gonzagas named after that saint. The Bulldog head, there's a lot of Bulldog heads out there. There's not a lot of that logo, the WSU logo. Zags is a little different. I think they could go, get a lot more registrations around Zags. But does that mean Gonzaga doesn't have rights? Does that mean Gonzaga can't stop people from printing their own Gonzaga sweatshirts? No, it doesn't mean that. They have common law rights. They can sue people in federal court and, go back maybe 20, 30 years ago. Those common law rights maybe were only in the Northwest, maybe on the West Coast, where people knew about Gonzaga University. If someone 20, 30 years ago in Maine, I can't say 20 years ago, shoot, it's, right, 30, 40 years ago, in Maine or in Florida wanted to print Gonzaga University sweatshirts, Gonzaga University here in Spokane, Washington maybe could not have stopped them because their common law rights were restricted to their geographic notoriety. Okay. Now, however, they're like, hang on, number 2 in ESPN's BPI rankings for this upcoming season. All right. They're perennial NCAA tournament team. They made it to the national championship game a couple years ago. Everyone in the country that knows anything or cares about basketball knows about Gonzaga, right? So they can now enforce it anywhere in the country, even without a registration. Okay? But remember that Sonic drive-through and the Mattoon, Illinois example. Okay? A federal registration allows you to lock people in place, okay, so that you can expand freely without trying to get stopped. Okay? Oh, it's 1 o'clock already. Jeez. Okay. So everyone want to stick around for a little bit? Megan, are we good? Kelly, for a little bit longer? Yeah? Okay. All right. So likelihood of confusion. Maker's Mark actually has a trade dress registration for the red dripping wax. And when Cuervo came in with a red dripping wax, they enforced it against them and won because they convinced a judge that there was a likelihood of confusion. Would you guys be confused? Well, a judge was. Okay. The other thing we encourage on the trademark side, just like any other type of IP, we encourage companies to take a holistic approach. We just don't just register your main name and call it good, or your product name and call it good, or your logo and name and that's it. You should always be thinking about what other things can I protect. Okay, this is Apple. Apple is the most valuable brand in the world, and Forbes in their 2018 rankings said that they're worth $182.8 billion, just their brand alone. Okay, what is their brand? Well, of course it's the word Apple. Of course it's that. Everyone recognizes the Apple logo. But they also have trademark registrations on the shape of icons, the look of their icons. Trade dress registration on the look of an iPhone, right? It was litigated in the Samsung case. They have a trade dress registration for the look of their Apple stores. They enforced it against Microsoft over on the west side of the state. Okay? They don't have a trademark registration for that cool clip art I put up. What that means is enforcement. Protection plus enforcement equals strong trademark rights. Okay? Trademarks are the only type of intellectual property that you have to enforce and police, or else you could lose your rights. Okay, patents, you can pick and choose who you want to sue, and there is a equitable statute of limitations called latches. If you knew of an infringement, you can't go sue them 5 or 10 years later. But trademarks, if you fail to enforce against these guys that you don't really care about, but they're technically infringing, then when you go to enforce against a competitor that's infringing, they might say, well, you abandoned your rights when you didn't enforce against those guys. So trademark cease and desist letters are rampant. Okay, I tell people, don't take it personally if you get a cease and desist letter for trademark infringement. It's just a guy like me on the other side telling them, well, you have to send a letter. Sometimes a letter is all it takes to do your enforcement and police your rights. Okay? Send a letter. They send a good letter back of why there is no infringement. You file it away and say, okay, we're good. I don't care about them. But the ones that you do care about, you have to enforce. Okay. Use an attorney. So the cost, so a federal trademark registration, we've already established, is not a requirement to have trademark rights. You just go ahead and start using it in connection with the sale of your goods or services, put the TM there, you have some trademark rights. But a trademark registration at the federal level is a no-brainer for most companies, okay, that are doing business across state lines at least, okay? Why? Because it, again, locks up potentially the entire country, your rights within that, sphere of your goods and services that you're selling, and it's pretty cheap, right? It's like $1,000, $1,300 for a trademark application instead of the $8,000 to $12,000, okay? So it's usually a no-brainer. Do your own searching always first, okay? If you are still not sure, and we have a bunch of clients that want us to do some searching too, and that's cool, we can do that, we charge for that. Cease and desist letters, of course, but you can police your own marks yourself. Every single person that's starting a business or already has a business should set up Google alerts. Set up Google alerts for your brand, your name. So I have it for a bunch of my clients and Leonese and my name, and so then I know when something's published on the internet and talking about me. Do it now. It's free. It's pretty easy. Copyrights. We're going to burn through this because we're already kind of slow on time. But copyrights are super important because if patents are the king, trademarks are awesome, copyrights are actually the queen of IP, okay? Very important. Basis in the Constitution like patents, okay? And everyone kind of gets copyrights too, right? I mean, everyone knows, like, if I illegally download a song, I guess I'm infringing someone's rights. That's a copyright you're infringing, right? Everyone knows that, you can't just wholesale snag a book or a picture and republish it as your own. That's copyright infringement. Okay, so that's what copyright protects. It's an economic right given to creators of original works of authorship. Okay, it has to be an independent, original creation, so you can't copy it from someone else, and it has to be fixed in some sort of a tangible medium. That doesn't mean tangible like a printed out piece of paper. It can be electronic as well, as long as it's fixed. Okay, so this presentation right now that I'm giving, if it wasn't being recorded, is not protected by copyright. My slides are, because I've reduced it to a fixed, embodiment here. This recording that's going to go on YouTube or whatever is protected by copyright. Okay, but my presentation in and of itself is not protected by copyright. Okay, it's the expression, not the idea. Automatic protection for copyrights also. Okay, you don't have to have a registration to have copyright protection. Use that encircled C. At the bottom of everyone's website should be encircled C, the year of last update or creation of the content, and then the name of the owner. Okay? The encircled C is different than the encircled R. Remember, the encircled R you can only use if you have a federal registration. Encircled C, you just use it. Okay? A registration, however, is sometimes very important for companies, especially companies that are built on the back of things like software. Okay? Your software should be registered, should be a registered copyright. Okay? The code is protected. A registration gives you some pretty good teeth if you ever have to enforce against people. Well, when am I ever going to enforce against someone? If I'm a software company, how am I ever going to prove that a competitor is using my code? Well, what about your employee that just left and goes to your competitor or someone else, and all of a sudden they have a product that's very similar? Did that person, were they exposed to the source code, to the code? If the answer is yes, then you could have a copyright claim right there. That's probably the most common example of a copyright infringement claim. Okay? And you're going to wish that you had that registration because you get statutory damages, so you don't have to prove your damages at trial, and you get potentially attorney's fees and up to triple damages. So it's really adds a lot of arrows in your quiver to get a registration. Copyrights are they're not perpetual like trademarks. Okay, it's 120 years for work made for hire, so anyone who creates it within the scope of their employment, or life of the author plus 70 years for any other copyright. Okay. What is a work made for hire? So here's an example. I have my phone again. My phone's great. It takes pictures. I hand my phone to Chris over here, and I say, Chris, take a picture. I'm presenting right now. Come on, take a picture of me. So it's my phone, a picture of me, and I say, I don't really trust your creative judgment. I'm sorry, Chris. I'm going to tell you everything I want about this picture. In fact, stand up on this table and take it from that angle and take it only after I say cheese or whatever. So Chris does no thinking about the picture, right? No creative juices. It's my phone and it's a picture of me. Who owns the copyright? Chris owns the copyright. Why? Because he pushed the button. He pushed the button. He created that copyright-protected work by pushing that button, okay? This is a huge issue, okay? This is an issue that we deal with several times per month. IP ownership is the single most prevalent issue in the world of intellectual property, okay? Because there's misconceptions. If I hire a software developer to develop some software for me, and I pay him, and we even talk about, hey, I'm going to own this, right? Yeah, you'll own it. But there's no written agreement saying that they're transferring the copyright to us, to me. Guess who owns it still? The software developer. Whoa, that could be bad, right? Yeah, I've gotten into a bunch of situations where we've had to go back and get assignments. It's one of the first things I ask people, in the context of, okay, they want me to start, form a corporation so I can go raise money. Okay, great. But what are we going to do when we get that corporation formed? We want to assign all the assets, including the IP in there. Do you own it? Well, yeah, I own it. Okay, show me the contract. Well, I don't have a contract. They said I own it. Okay, well, we're going to just go ahead and write something up and have them sign it before you make it big and they want, to be paid a whole bunch more money for that signature, okay? You have to sign it. If it's an employee, however, creating something within the scope of their employment, then you do own it. The business owner, the employer owns it. Not only that, but for copyright purposes, the employer is the author, okay? So we're talking about independent contractors doing software development, websites, any creative work at all. They own it unless you get it assigned. Okay, there's it's not super magic language, but there's wrong language and right language in a contract. So I know that there's, I've seen a ton of contracts. Oh yeah, we have a written contract. Okay, great, let me see it. It says that, so-and-so, the developer will assign to so-and-so. Wait a second, will assign? That's an agreement to agree. That's not enforceable. That's not a present assignment of rights. You need to have a present assignment of rights. This is a big deal. Everyone should have this on their radar, okay? Questions about that? Yeah. 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 See any issues there, Ethan? Yes or no? Yes. Okay. So there are issues. Just the action of taking the picture is potentially creating a copy of your copyright protected work. Just taking a picture. Okay? And that's one of the exclusive rights that copyright owners have, is the right to create copies and distribute copies. Okay? No? Maybe you don't care. In most cases, you don't care. In most cases, you don't care. Yeah, it's PR, right? Are they really going to go do what you're doing? Well, you really don't care until they try to compete with you using your IP. Okay? Then you say, hey, you're violating my copyright, stop. Usually that's the end of it. People don't intentionally usually want to infringe someone else's IP. Okay? Questions? Okay, so again, copyrights, ideas and concepts in and of themselves are not protectable. Ideas and concepts are not protectable. What is protectable? Either you have something that's patentable, or you have trade secrets, or you have trademarks, or it's the expression of that idea and that concept. And that is what's protectable under copyright. Code is a great example that people forget about all the time. When to use an attorney, talk to an attorney if you just have questions. A lot of people can do their own. That's the one type of IP that we actually say sometimes you can do your own registration. The Copyright Office is pretty user-friendly. It's pretty cheap. And it's, in most cases, hard to screw up. Software is the only time that it usually makes sense to use an attorney, because there's certain ways that you can get around essentially disclosing your whole source code, which is what the Copyright Office would prefer, and you don't. want to do that because your source code could be your single most valuable trade secret. Okay, need to keep that secret. Questions about copyrights? Okay, we're going to do trade secrets real quick and then get everyone on their way. It's the fourth bucket of IP, and people forget about trade secrets. Kind of the forgotten stepchild of IP. But they're important. Why? Because there's some serious teeth to trade secret laws. Okay? There's some federal protection. There's mostly state law protection. Okay? There's a Uniform Trade Secret Act, and then now there's a federal layer to that. But also, there's potential criminal repercussions for people who misappropriate trade secrets. We've seen it before, right? We've seen like the Chinese worker who got a job at Google and then all of a sudden is on a plane to go back to China and has these hard drives and other stuff, and all of a sudden they're getting arrested off the plane or whatever it is, right? That's misappropriation of trade secrets. And there's also economic espionage and those type of things as well. But trade secrets are important. What is a trade secret? Well, it's anything that is not commonly known, okay, is a secret, and derives an independent economic value, okay? In other words, it would be valuable to your competitors if they knew it, okay? And it has to be subject to affirmative steps, reasonable means to maintain the secrecy of that trade secret, okay? So what are reasonable means? That could vary from one trade secret to the next. The best example of a trade secret is the Coca-Cola recipe or the KFC 11 herbs and spices. Is that right? Those trade secrets, maybe eye scanners in a vault might be reasonable for those type of trade secrets. For most companies, how do you protect trade secrets? Make sure that if you're going to disclose, well, first of all, make sure you don't disclose it unless you absolutely have to. You minimize the amount of people that know that specific trade secret, okay? Take source code, for example. Source code, you don't want people to know, except the developer has to know it, maybe a few other people, and maybe if you're going to be acquired, finally you'll let someone see the source code or something like that under strict terms of confidentiality. That's the other thing. If you do disclose it, it has to be subject to non-disclosure agreement, okay? Password protection, those type of things. Okay? That's how you protect trade secrets. Anything that you think could be patentable, but you're exploring whether or not to actually file a patent application is something that you want to maintain as a trade secret until either you have something filed and there's a business reason to disclose what it was in your application, or patent applications are published most of the time, unless you request them not to be, about 18 months after filing date, your first filing date. Once it's published, it's made public, okay? And it's no longer a trade secret. Fine, it's out there. Okay, that's part of the deal, okay? But you should maintain it as a trade secret. So source code, those type of things. Customer lists. Everyone talks about data. Well, I own that data. No, I own that data. What is data? Data is usually just what it is. It's a fact, right? Usually. If it's like a list of telephone numbers, it's a person's name and their telephone number. Those are facts. But the way that they're arranged and compiled can be protected by copyright. Also, if it's kept secret and would be valuable to your competitors, which most data is these days, you can maintain it as a trade secret, okay? Your back-end database, your back-end data that you're collecting in your software company or whatever it is, your platform, that should be protected as a trade secret. Like I said, patents before they're filed in KFC. Okay, so we kind of talked about this. The other thing is contracts. So really fast contracts. When do you need an NDA? Well, we've already talked about NDA. First of all, what is an NDA? Non-disclosure agreement. Some people call them CDA, confidential disclosure agreement. Some people call them confidentiality agreements. They're all the same thing. The point is to impose confidentiality obligations on someone else because you're going to disclose something to them. Usually in the business context, people want them to be mutual, so it goes both ways. If information flows both ways, both parties have an obligation. But they're super important. You should have a standard stock NDA that you use. Non-competition agreements. Those are super important for key personnel, okay, key employees. If they left, even if they complied with their confidentiality obligations, which usually lasts for a number of years after they're terminated or whatever, if they went and worked for a competitor, would they inevitably disclose something that would harm my company? If the answer is yes, then a non-compete's pretty important. I actually do non-competes as mostly I treat them as standard part of our contracts for founders, okay, for a founder group, for a startup. That's usually part of kind of our, by the way, we do like a package for startups, call it kind of a corporation in a box, investment ready startup, for kind of a standard amount. They're vetted forms that investors have seen and have said, oh yeah, well that's exactly what I expect to see, that type of stuff. Non-competes, confidentiality agreements, invention assignment, which is the last one here. Those are all things that investors want to see, have to see, if they're going to feel comfortable, okay, investing in your company. IP assignment's key because if you don't have it, then you might not own what you think you own. Okay, we already talked about copyrights. Patents are the same thing, but even if an employee that creates something within the scope of their employment, if they're an inventor on a patent, you don't own it as the employer unless you get that assignment, okay? So super important. Okay, questions, I'm done. Questions? No. Well, thank you guys. IP is not the most exciting thing, but it's super important, okay? And it should be on your radar. And if anyone has any questions as you guys kind of move forward, feel free to email me, shoot me a call, whatever. I have cards up here. My contact info is right here. All right, thanks you guys. Oh yeah, go ahead. Yeah, so this will be on the Startup Spokane YouTube channel as well, my understanding.